Awesome. All right. Well, hello and welcome everyone. Thank you so much for coming to our workshop here on how to administer an estate after a loved one passes. My name is Duncan Hardiman. I'm an AmeriCorps Vista and the Community Program Coordinator here at Pennsylvanians for Modern Courts. I'm joined by Michelle Jordan, who is our Director of External Affairs there at PMC. I would like to thank the Conshohocken Free Library and the Montgomery County-Norristown Public Library for co-hosting this event with us. And I'd like to especially thank Maureen Farrell for presenting with us. I'm going to start with a little bit about Pennsylvanians for Modern Courts, then I'm going to introduce our speaker and I'll hand it off to her. So, Pennsylvanians for Modern Courts is a nonpartisan nonprofit founded over 30 years ago with the goal of ensuring a fair and impartial judiciary. Today, we offer a series of programs like these to help keep the public informed about the court system and make sure everyone is prepared for court with their knowledge and confidence. Our speaker today is Maureen M. Farrell, the owner and principal of the law offices of Maureen M. Farrell. Ms. Farrell's firm concentrates on estate planning and estate litigation to protect hard-earned family wealth and assets. Ms. Farrell is a trusted advisor representing a diverse clientele in preparing wills, special needs trusts, power of attorney for health and finance, personal property memorandums, guardianships, Medicaid planning and nursing home contact review. Ms. Farrell is the current probate and trust law selected representative to the Philadelphia Bar Association Board. She was the former president chair of the Solo, Small, and Mid-Sized Committee of the Philadelphia Bar Association. As such, she counseled numerous attorneys on how to start and run successful practice and moderated and spoke to attorneys in the community in over 30 different speaking engagements. Ms. Farrell serves a number of national, local, and charitable and civic organizations. She's an elected member of the board of the Philadelphia Bar Association. She has published numerous articles as an associate editor of the Philadelphia Bar Reporter. Ms. Farrell advances the creative fundraising for many organizations: the Support Center for Child Advocate, Community Legal Services, St. Mary's Interparochial School, and Women's Way. She served as the vice president of Brahon Law Society, an organization which fosters the development of Irish lawyers in the Philadelphia area. Ms. Farrell is a frequent lecturer and moderator with priority engagements with Rosemont College, the Philadelphia Bar Association, Drexel Law, Jenkins Law Library, and the Brehon Law Society. She has been repeatedly recognized as Pennsylvania's Superior Lawyers Rising Star. She's been recognized as an Irish 100 Rising Star in 2017, and as the Wellness Committee co-chair, was recognized as a Bar Star this year. She received her JD from Widener University School of Law, her Master's in Education, magna cum laude from Temple University, and her BA from Villanova University. She is a marathon runner, having run 15 marathons, and she goes the distance with her clients. You can see her contact information up here on this slide, and I'll hand it over to her.
Oh, thank you so much, Duncan, for that great read. Really, I appreciate it. So I want to thank everybody for attending tonight, and I want to thank Pennsylvania for Modern Courts, because this is really about what I like doing. I like helping people and giving information, especially over the holidays, to protect you and your family. And so tonight we're going to be talking about this concept of administering an estate. And Duncan, if we could just pull up the estate slide real quick. I think it's about the estates. I just want to talk about, that one thing. So exactly, the one before, I think, but
Sorry.
I just want to talk about everybody has an estate. I know it sounds like a grandiose concept. Like when we hear this word estate, we're thinking of like large estates. So tonight, the topic is administering an estate. We all have them generally. And so an estate is made up of your property, different types of property. Okay, so when we talk about a will later, okay, what you're going to be doing in your will is giving away your property after death. Okay, and so what you're giving away is you're giving away your estate. And for example, like your home that you live in, that's typically like the largest part of your estate, and that's called real property. Okay, so you have your home and then you have the land around it. You could also maybe have a vacation home, which is also a part of your estate. You might have some personal property. I feel like we all have personal property. We have like books, china, your car. I just want to say also pets is a type of personal property. I have a lot of people who are really attached to their pets. And that's something that you can give away in your will. You can also create a trust for your pet. So all these things, also digital property now, like your email address, if you have any type of blogs and things online, those are all types of personal property. Okay, these are all things you give away in your will. And then there's also property, your bank accounts, so your savings account, your checking account, and then there's other types of property, okay? And this type of property is called non-probate property. And I know these concepts, they're kind of like these terms and these concepts can be a little bit cumbersome, the terms. So I just want to talk to you about what non-probate property means for a second. It's right there on this slide. So what I just talked about was probate property. So things that are given away in your will. Okay, so I just want to make this really clear to everybody. Things that are given away in your will are things with your own name on them only, okay? So for example, if you have a savings account that is only in your name, that would be given away through your will. If you have a checking account that is in your name only, that's going to be given in your away in your will. If you have a house that the deed has your name on it only, and you always want to check your deed, okay? That would be given away through your will. These are what are called probate types of property. They're going to go through your will. That's what probate means. If you have property, though, where it's given away by contract, okay, so that means that it's not just in your name. So for example, if you and your spouse have a joint checking account, okay, when you die, that account goes right to your husband, okay, or wife. So that account is not going to go through your will or through probate. It's going to go through a separate process, okay? So if you have a life insurance policy that you have a form that you fill out and you specify who that policy goes to, a beneficiary, that is what's called a non-probate asset. It doesn't go through your will, it goes through that form or that contract. In Pennsylvania, if you have a house, and you can own your home as a married couple in Pennsylvania, okay? So if you own your home together and you die and the home automatically goes to your husband or wife, that doesn't pass through your will. Okay, so it's really important when we talk about will and probate and all these terms, like to understand what happens with a will. So a will is a way for you to give away your own assets. And this is really where planning comes in and like an attorney comes in. And I'm going to say, I mean, I'm an attorney and everybody knows that, but I think it's really important. The one thing I can say tonight is to people say, I don't want to, for various reasons, I don't want to draft a will. I don't want to see an attorney. It's not as expensive as you think. And it could save you hundreds of dollars. Okay. I mean, it really can. So it's very important to see somebody and just talk about your assets and what you have and think about, okay, what do I want to pass through my will? Okay. So like if I have a joint checking account, that's going to go right to my husband or wife. But what do I have in my own name and what's going to go through my will? And what's really important, guys, is like if you have a will and you spend all this time and money with an attorney, okay, and you're drafting this will, that you know where the will is located. Because after you die, you're going to, one of the first things you're going to have to do is you're going to have to find that original will. Okay, so I have so many clients that they have the will and they have it in a certain spot. And I tell them like it's very important to either put that will in some sort of safe deposit box. There are fireproof safes out there, things like that, but they can melt. But make sure that you know where it is, and you tell people where it is. So I just want to say something about the will. When you draft a will, one of the most important things you're going to be doing if you decide, okay, I'm going to, after tonight, or I'm going to get my will done, is you're going to be picking somebody called the executor. That person is going to be in charge after your death of making sure what you sat down and drafted with your attorney goes to the right people, okay? So not everybody can be an executor, okay? An executor, they have certain things that they have to do after someone dies, okay, or after your death, okay? They are in charge of making sure that these people get these assets. And a lot of times what can happen is if there's a mistake, let's say a beneficiary gets something they shouldn't have, or if you didn't distribute that asset properly, you gave one person, they needed the money quickly, you gave it to them, and then you didn't, you could end up getting sued. So it's very important, like, to talk to somebody about, okay, do I really want to be the executor? And do I want to take on the responsibility after someone dies of making sure all these people get their assets? It can be a very stressful type of thing. Okay, but that's one thing that is important when you're talking about your will, is who's going to be my executor? Who are the people I trust? I mean, there's never going to be a perfect person, but that's a benefit of doing a will. Doing a will, you could give to who you want to give to. You can give to charities. You can give to like, oh, I want to give $5,000 to a niece of mine. If you don't draft a will, okay, the state of Pennsylvania is going to decide who gets what. And so these rules by the state of Pennsylvania were adopted a long time ago. So sometimes the people that you want to get things, maybe you want to even give something to a friend, they're not necessarily going to get them because the state of Pennsylvania decides, okay, I want to let's say give something to my stepdaughter. You may not be able to. Okay, so that's another thing. It's important to realize that if you don't do a will, somebody else, the state of Pennsylvania, is going to decide who gets what, and you may be cutting out people that you don't want to cut out. And also the state of Pennsylvania is going to then decide who the executor is. Okay, so that can be something that turns very contentious if you don't have a will. Okay, so these are things I want you to think about when we talk about administering an estate. Your estate is going to be the probate assets under your will, and it's also going to be the non-probate assets. Okay, those two things are going to make up your estate. All right, so let's like fast forward now to what do I do if someone dies? Okay, which is a very stressful time. Okay, and so the first thing is, when someone dies, you want to figure out, okay, who's the executor? Who did I pick? Okay. And the executor has to find, and you see the slide which lays it all out, the executor has to locate the original will, okay? It's really important with this because let's say you bring the original will into what we call probate, okay? And we're gonna go over what all that means. And the original will has like a rip or a stain on it, or there's a page missing. You're gonna have problems with getting that original will through the court, okay? And also, if you have a copy, that's another issue. You're going to have to ask the court to probate the copy. So you want to make sure that original will is kept in that really safe place, as I talked about. And a copy is something you're going to have to spend money on if you only have the copy to get that copy through the courts, okay? So you're going to find the original will, and I definitely suggest talking to your attorney here if you're the executor, okay? Because you're going to be in charge of, okay, how many assets did my uncle have? You're going to be surprised sometimes, like how many assets people actually have. You have no idea sometimes. So it's like, okay, I'm the executor for my uncle. So I should sit down with my attorney and try to figure out, okay, what I have to do. Because after someone dies, you're going to have 9 months to probate the estate. So what that means is you're going to have 9 months as the executor to give out these assets to the proper people. Okay, but there's a lot of steps that you have to do. So what I do, like when people come into my office, I have a checklist. I love lists and I love following them. And so what we do is we go through this checklist, like this is what you have to do within 3 months. This is what you have to do within 6 months. This is what you have to do within within 9 months. And then we talk about the people who are getting the assets, because sometimes what happens is I have a will where someone got told that they're not getting anything. And so in the will, it might say, I'm estranged from you, you're not getting anything. And so that person might be very contentious. And sometimes I have wills where they're like, if you try to contest it, you're going to get more fees. I mean, there's all kinds of things that happen. So I sit down with the executor, we talk about what's in the will, we talk about this process that needs to be completed in 9 months. Okay, so, but if there's no will, we talked about before, there's either testate, which means you have a will, okay, or there's intestate, which means you don't have a will. So if you died intestate, okay, that means that there's an order of how your assets are going to be distributed. So for example, like if it was just you and your husband, everything would go to your spouse. But like if you had you and your husband and your child, but if you had a stepchild or an adopted child, there's all different rules about who gets what. Okay, so with intestacy, there's no executor, right? Because remember, you didn't pick one. So what's going to happen is you're going to have to go to court and get the executor chosen for you. Okay, and so what's going to happen is, let's say I have me and I have 3 children. Okay, and I'm not married, and I die. And so let's say these 3 kids, 2 get along and 1 doesn't. And so what's going to happen now, and I don't have a will. So what's going to happen now is one of my 3 children gets to be the executor. And what happens is sometimes they're not going to agree. And sometimes they're going to say, well, I'm not letting you do it. You're not doing it. And so what happens there is that you now have to go through like another court process in order to pick the executor. Okay. And this can all be time consuming. And remember, like, you're grieving during this time and you've got to go through all this stuff. So picking somebody to be the executor is really important. I mean, sometimes what you want to do is you're picking out somebody in your will and you can explain why you picked that child. You can also pick out a successor executor in your will, which is really important because sometimes the executor is traveling or they're sick. They can't do it for one reason or the other. So it's important not only to pick out one executor, but I always pick out a successor, or you could even pick out someone even after a successor. There's also a corporate executor you can pick out. There's fees for that. I don't necessarily always suggest that. That's an option too. Okay, so you're going to either now, after someone dies, you're going to locate that original will. If you can't find the original will, if you find a copy, you can still probate the copy. Okay, I just want you guys to know that you can probate that. Or you're going to have no will and you're going to probate with no will. Okay, so what's going to happen now is you're going to go to the funeral home. Funeral homes typically have the death certificate. And so when you probate your will, you're going to need that original death certificate. Okay, so the 2 things you're going to need, originals, are you're going to need the original death certificate, this copy, and you're going to need the original will. So copies, the Register of Wills is not going to accept copies on those things. I want to explain a little bit about each county. So I live in Philadelphia. So if I died, my will would go through probate in Philadelphia County. So let's say I have my house here in Philadelphia and I have a vacation home in New Jersey. So what I would have to do now, I would have to do 2 probates. Okay, I'd have to do like my probate in Pennsylvania. Okay, because that's my residence, but I would have to add on that probate in New Jersey. That's called ancillary probate because I have that vacation home. Okay, so that's something also to think about. Like, do I want to do not a will, but maybe some kind of trust to put the 2 houses together in one state? That's a whole different conversation. But the probate of your estate is always going to be where you reside. Okay, so if you reside in Montgomery County, even though you have property in other counties, if your residence, you're domiciled in Montgomery County, that is where you're going to probate your estate. Okay, So each county has an elected official, and that person, I think, Duncan, I think there's a slide on the Register of Wills. Perfect, thank you. That person is going to be the one in charge of probating, helping you with probating your estate. And they have staff there. They have clerks that work with you. Many of them do marriage licenses as well. So for example, Montgomery County has their own elected Register of Wills official. So does Philadelphia County, Camden, Bucks County, Cumberland County. All different counties have different Register of Wills. And each county is slightly different in how they conduct their business. Okay, so for example, Montgomery County was doing in-person probate, some in person. Now they have electronic filing. But for those of you who are not versed in the computer, you can still go in person to do this work and get the estate probated. Okay, so each county is slightly different on how they conduct their business, but many of the forms that you're going to use are all the same in all the different counties. So that's nice. Okay, so you're going to get the original will, you're going to get the original death certificate. Okay, and then you're going to get what's called an estate information sheet. I think that's one of the slides. Thank you. So the estate information sheet, the executor is going to fill this out. It's just a lot of like biographical information about the person. You're going to have their social security number. You're going to have different things about the person. So that's going to be your cover sheet. So these are all things, they have these names, estate information sheet, but the information is relatively straightforward in terms of filling it out. Okay, so you're going to want to fill all these things out before you go to the courthouse to probate the estate. Okay, so you're going to fill this out. And the next form you're going to fill out is called the petition for probate. Yes, thank you. So they call this petition for grant of letters, but really it's just filling out more information. Remember, we're calling this administration of the estate. So it is a lot of administration. There are a lot of tasks involved. Okay, so petition for grant of letters, what that basically means is getting the ability, the executor is going to have the ability to administer the estate, meaning to give out the property. That's what all this is doing. Okay, so in this petition, you're going to list who the beneficiaries are. You're going to list different things in this petition. Okay, and the petition is going to ask you, do you want short certificates and things like that? And you can ask when you go to court what that is. Okay, but short certificates are just a way of proving that, okay, I'm the executor and I was appointed, and they're forms that you're going to bring to like the bank in different places. Okay, they're generally like $10, I think, for each short certificate. Okay, but the clerks are generally very helpful. But that's one thing you're not going to have to worry about filling out. Okay, just how many short certificates. But I always suggest generally with my clients, like get 1 or 2 of those. Okay, those are things you're going to bring to the bank to like close down the bank account. Okay, you're going to bring that to the bank with the death certificate. You're going to bring to maybe if you have a brokerage account, you bring that short certificate, because when you get your certificate, it's very long generally, and the short certificate just essentially, that's the term, it shortens it up. Okay, so what that means, grant of letters, means there's 2 types of letters. Remember, this is all like from the olden times. That's where we're hearing these words like grant of letters. Okay, there's 2 types of letters. There's letters testamentary, that means you had a will. Okay, and there's letters of administration, but they're both essentially the same thing. Okay, so what you're going to do is you're going to get your original will, you're going to get your original death certificate, you're going to have your petition for grant of letters, you're going to fill that out, you're going to fill out your estate information sheet. Okay, then you're going to have, most of the time you can't give a personal check. I think you can give a credit card. Okay, because what you're going to have now is when you go to probate, you're going to have a probate fee. Okay, so what that means is when the clerk is looking through the will, there's going to be a certain amount of assets, okay, that are going to go through this process called probate. So let's say, for example, like I have, I don't know, $100,000 worth of assets. Okay, in order for the court to go through this process, they might charge me $200. Okay, so Probate fees are dependent upon how many assets that you have. So this is something where I do planning. Planning comes in. So like if people have $2 million worth of assets, okay, to give away through their will, remember back to what I'm giving away that's in my own name, my probate fees could be very significant. Okay, they aren't that significant in some of the counties. Like if you go to Florida, your probate fees could be like astronomical. It's not as bad in Pennsylvania. Okay, but so whatever assets you're giving away, you're going to pay this fee on the giveaway of assets. That's the probate fee. Okay, so you're gonna have to pay that when you're there. And then when you complete, you're going to sit down with the clerk, and when you complete this process, what you're going to get is this nice certificate with a gold seal on it. And it's going to say that you are now the executor and you have the ability to distribute these assets. Okay, you're going to get that long certificate, and then you can pay for those short certificates if you want. Okay, so it's really important now, once you get the certificate, okay, and you're the one, so you're the executor, you're now appointed. One of the most important things you can do is you're going to want to notify, this is what the executor has to do, notify beneficiaries that they are getting something. Okay, because beneficiaries, what you don't ever want is accidentally to exclude a beneficiary. Okay, so I've had beneficiaries before that have gotten something and they've actually told me they don't want it. Okay, so I've had, like, for example, I've had brothers and sisters, like 5 or 6 of them. One of the sisters was extremely wealthy. Like she was like great, we're talking crazy wealthy. And so I sent her the certificate that said she was entitled to get something under this will. And then she told me she didn't want it. Okay, so what I had to do was tell the other beneficiaries that they were getting it. All right, so when you're the executor, you're going to have to send this form to each and every beneficiary. And thank you, it's called the certificate of notice. You're going to have to tell them, you don't have to tell them exactly what they're getting, but you do have to tell them that they're getting something. Okay, so you tell them that they're getting something, and then you also have to tell the court that you did it. Okay, so this has to be done within the first 3 months. And making sure those beneficiaries know. It's really, really important because you don't want someone crawling out of the woodwork saying you didn't tell me, and then other people accusing somebody of something they didn't do. Okay, during this first 3 months, there's a lot going on too. You may be getting bills from credit card companies that you want to like look over as the executor. Okay, sometimes you'll get a lot of bills. I've gotten, and my clients have gotten, a lot of duplicate bills. Clients of mine have gotten roofing scam bills, okay, things that they've been victims of scams. So if you're the executor, you have to look at each and every bill that comes in, okay, and decide, okay, are these charges real? Some of them are duplicated. I mean, some of them I've had fake charges that were billed to the wrong person. So remember, if you're the executor, you have to distribute the money, the asset, whether it's property, money, whatever it is, to the beneficiary. So if you pay off, like let's say a $10,000 credit card bill that was wrong, those beneficiaries are going to say, what did you do? Okay, like if you didn't sell, like let's say you have to sell a house. I do a lot of those. You're the executor and you have to sell this house. If you didn't sell it at fair market value, if you did something, they're going to be like saying to you, what did you do? Okay, so this job, really what it is, it's a job. It's not necessarily for everybody. So I want everybody to think about this too when they're taking this on. So within the first 3 months, you're gonna get the stop the mail. Okay, there's gonna be mail coming. You're gonna get that mail forwarded to your house. You're gonna, with Social Security, you're gonna deal with that. Okay, you're going to, I want to say this one thing, it's very important. You definitely want to change the locks if there are houses involved. Okay, I actually have had houses that have been robbed, things like that. You need to go over to that house and change the locks. And another really important thing is the executor, if their property is involved, if there's insurance on the property, I want you all to realize this, it's in the name of a dead person. You want to insure that property, okay? So remember, as executor, you're in charge of protecting that asset. So you want to, if you get a property, go over there, change the locks, get insurance, in the name of the estate on that property. And that's a whole nother, we could have a whole nother conversation on that. These are the things you want to do. We're talking about a checklist within the first 3 months. Okay. And you're going to put in that certificate. You're going to get that done. Another thing you can do in Pennsylvania in the first 3 months is everyone has to pay generally inheritance tax. Okay. So in Pennsylvania, thanks Duncan for changing these up. In Pennsylvania, inheritance tax is based on your relationship to the person. Okay. So inheritance tax, you have 9 months to pay the inheritance tax, the executor, from the date of death. Okay. And you can ask for an extension if you need it. So don't worry, if you need an extension, you can ask for it. So within the first 3 months, though, after death, if you can prepay the inheritance tax, you get a 5% discount. This is only in Pennsylvania, it's not New Jersey. Okay. So if you want to prepay it, though, you don't have to fill out all the paperwork. You just write out the check, what you believe it is. Okay. It can save you a significant amount of money. So that's something you definitely need to know, especially if you have a really large estate with a lot of assets. But let's say you have an inheritance tax, it's that you've got to pay, and it's like $10,000. The estate has to have the money to pay the inheritance tax. Okay, so that's an important point. And let's say the estate there was a life insurance policy. Okay, a lot of times people will take out the life insurance policy and they'll take it out and they'll have like $100,000, or even if they only have like 15,000 or 10,000, you can use that money to pay off the inheritance tax. Okay, so inheritance tax is something that the executor is going to have to pay from the estate. Okay, and inheritance tax is based on if you're married and you have a spouse, there's a 0% rate. If let's say the inheritance tax, you're giving property away to your children, it's a 4.5%. If it's like brothers and sisters and grandparents, things like that, you have different rates. So like if you're giving money to a friend or assets to a friend, they have to pay an inheritance tax. Think of it like a transfer tax in Pennsylvania. Okay, it's a 15%. So if you give money to a friend, they're going to have to pay 15% tax. But think about it though, like if a friend gets $30,000 or even 500, whatever they get, they're still getting something. So they're taxed on something, but they're still getting money. Okay, so that's where planning comes in too. Like if in terms of avoiding inheritance tax, I talk a lot about that, like what property is subject to inheritance tax, and like certain property is not subject to inheritance tax. Okay, so you want to think about that. So for example, like if you have a property and it's your own property, you're the only one on the deed, okay, and your property is worth $250,000 and you give it away to your child would have to pay 4.5% inheritance tax on the property. Okay, but for example, if you have a property that's in a husband and wife, like if you're in a husband and wife's name, okay, and husband dies and it's in right of survivorship, what they call it, goes to the wife, there's not going to be any inheritance tax. Okay, so this is all about, a lot of this too is about how property is titled and what goes. Remember, if it's in your own name only, then that's going to go through probate and you're going to have inheritance tax too. Okay, so this is where planning comes in, where sometimes you want to turn certain assets that would go through your will maybe into joint assets so you can save money that way too. Okay, I think we're back to the certificate, and then if you could just go back to I think the slide about paying debts and things like that, please. Great, thank you. Paying off debts too, be careful with what you pay off, okay, because there can be Medicaid liens is another one, because at the end there's an order of debts. Okay, so certain debts are like more important than others. So like secure credit cards versus unsecured credit cards, things like that. I would definitely talk to an attorney about like especially if it's a larger estate, about how to pay off things, when to pay off things like that. Thank you. So paying off debts, don't necessarily, like, you can pay off some of them maybe as they come in, but like if there's a very large debt, you want to be careful. Okay, but at the end, when you fill in the inheritance tax, any of the debts that you paid off, you can get a deduction for that. Okay, so that's the inheritance tax form. We could do like a whole hour or more just on that, just how to fill that out, but that's for another day. It's expenses like funeral expenses, those things are deducted off of your inheritance tax. Even if you had like a luncheon too, we can talk about deducting that. If you closed real estate of the estate, that is also deducted too. So things can be deducted off your inheritance tax form, and we can talk about that too at another time. Next thing is the inventory form. I think that was one of the slides. Awesome, thank you. So the inventory form is something that you're going to have to fill out as the executor about the property. Okay, so you want to be careful with this form. You're going to fill out all the different, like, okay, was there bank accounts? Okay, was there real estate involved? Was there personal property involved? And with the inventory form, when, let's say I have a piece of real estate, somebody dies. A lot of times you're going to want to get an appraisal on that property, because when you discuss the real estate in the inheritance tax form, you're going to have to put a value of the property. Okay, so you're going to either have to put the value of the property, like a fair market value. I typically get my properties appraised. But you can also, like, if you get a property and you sell it, you can put in your inventory form the sale price. Okay, but this is also a matter of strategy depending upon what you do. You cannot use the sale price if you sell the property after 1 year of death. Okay, so it's important as the executor. This is one thing where, okay, should I get certain things appraised? Like, do I have a lot of things in the house that need to be appraised, like furniture or artwork, things like that? You're going to want to hire a competent appraiser to appraise these things for you. Okay, but some people just are like, oh, it's all a bunch of junk in the house, like it's not worth anything. Then a lot of times what I'll just say, if it's like, let's say just worth like $500, we don't need an appraiser. Okay, we need an appraiser though, like when we have a lot of stuff. And remember, back to those beneficiaries, you know, that protects you too as the executor. Like, what are these things really valued at? Okay, so these are all things to think about, but all these things are going to be in your inventory form. Okay, so you're going to have to report all of this. I just want to tell you, as the executor, it's really important to distribute things. I had a client that there was a stock that the executor never distributed. They just never distributed some of these stocks. Okay, and they were worth a good amount of money. And they didn't distribute them. And what essentially happened is whatever it was, I cannot remember, went down in price. And literally this was worth a lot of money. And because the executor didn't distribute it in time, they got nothing. Okay, so this is like, if you have stocks and bonds and things like that, you have to sell them. You have to distribute them. You cannot leave them sitting there, okay? Because you're gonna, that person ending up suing, okay? They're gonna end up suing. So that's another thing. You're gonna wanna list all these things on the inventory form that are part of the estate. In terms of a commission, I just wanna mention this. Executor can be a ton of work, okay? And you are entitled to a commission. Okay, so that is something that's determined by statute, and you can get a certain percentage. And sometimes, I mean, I have executors that have spent so much time. I mean, they've gone to the bank, they've done different things. I mean, it just is so time consuming. So that is something definitely that, you know, you want to disclose to your beneficiaries right away that you'll be getting this commission. Okay, because you don't want any hassles in the end, like, why are you taking the commission? What did you do for the commission? Okay, you want to also, as an executor, I always keep track of what I'm doing, my time, just to be clear, like, okay, this is what I did. You know, I wasn't just playing around here when I was doing all this work. Let's see, intestate and testate estate. When you're distributing assets on both of those, it's the same process for both of those. Okay. I want to say something too about setting up an account. I think that's one of these slides, Duncan. So when you become the executor, one of the first things we talked about, you're going to certify that property. You're going to tell the beneficiaries what you're going to say you're getting something. You don't have to tell them what, but you do have to tell them you're getting something. You're also going to be in that first 3 months. What you want to do is you want to set up an estate account, okay? Because what's happening now is during probate, everything is in the estate's name. So like, let's say it would be like, if I died, it would be the estate of Maureen Farrell, okay? The estate of Maureen Farrell is like a legal entity on itself, okay? So you're going to want to, with the estate of Maureen Farrell, you're going to want to set up a separate bank account as the executor under the estate's name, okay? You're not going to be using the dead person's, their debt. So you can't write out checks in their checking account or anything like that. So what you're going to do is you're going to file online. This is called SS4, but it's what it is you're going to essentially be getting a number, an EIN number, you know, like an employee identification number for the estate. Okay, so you can get that online through the IRS. I'm happy to share the information if anybody wants to email me how to get that. Okay, so you're going to get that EIN number. And then once you get that number online, you print out the form and you print out that form and you bring it to whatever bank you want. Okay, you can pick whatever bank you choose. It doesn't have to be the person who died, called the decedent's bank. It doesn't have to be that. You're going to take that number and you're going to take the death certificate and you're going to take your, once you've been appointed, that short certificate with you to the bank. So, and you're going to bring those and then they're going to open the account for you. And any check that you write out, you're going to write out as the estate. So like if you hire an attorney or if you pay a realtor, whatever you do, write it out through the estate account, because then when you go to pay the inheritance tax, it's very clean. You can take all the deductions directly from the estate. Don't pay from your own account. Don't do that. Don't pay from the cash. Don't do any of that. Write out checks from the estate account. Okay, and the check should say on the top is estate of Maureen Farrell. Okay, so that's an important thing. And another important thing too in the state of Pennsylvania is you're also going to want to advertise the estate. Okay, so what that means, so you know how when someone dies, there's an obituary and it's beautiful and you're telling nice things about the person. What advertising is a very different thing. It's letting creditors know, okay, that someone has died. Okay, in Pennsylvania, the way that's done is through the paper. So what you're going to do is, I use a service for that and they're used to doing it. They do it all the time. And what happens is they're going to run this ad in both a legal and a non-legal paper, okay, for 3 weeks in a row. But you're going to have to call up these papers. Usually I do like the Daily News or like the Legal Intelligencer, but it may depend on your county. You may want to do like Mainline Times, different papers, okay, but you definitely have to do this. You have to run that ad, okay, and that's something that you have to show that you did through these papers. And so that sometimes what happens is creditors are looking at those ads, okay, so that's how they find you. And then the executor, sometimes you will start getting stuff in the mail if the creditors see those ads. Okay, so it's very important to make sure that's the way you let people know that in these short ads that someone has died. Okay, so it's very important that you do that. So we talked about the inventory form. We talked about the certification. And the next thing, I think, is there a slide, Duncan, I think on the inheritance tax? Okay. So
I believe it's just on the taxes here, yeah.
Yeah, thank you. So there's also income taxes. This happens all the time. I just want to tell everyone, I mean, estates can get very messy. I mean, there are people that I've had that haven't filed income taxes for years. Okay, so you may, as the executor, you're allowed to hire accountants. You can hire people to help you. You don't have to take this on your own. Sometimes, I mean, I have estates where they're rental properties. Sometimes you have a right as the executor to collect rent, okay, if there are renters in there. But a lot of times there are issues with people because they have like, okay, now someone died, I don't have to pay rent. No, not true. You still have to pay rent. Okay, so there are all kinds of things that happen. So with income taxes, you do have to file those, but you can get people to help you with these taxes. The inheritance tax too, you can get someone to help you to file that inheritance tax, okay? And the inheritance tax, you really want to keep track of the debts to the things you paid. Like if you close on a house, right, as the executor, if you sold a house, closing costs can be deducted. Okay, we talked about funeral expenses, attorney's fees can be deducted. Any of those probate fees that you paid can be deducted. This is where too, like, let's say sometimes people are like, oh, I don't want to use an attorney or whatever. My advice is go to an attorney for the executive for, even if you like the first meeting, to find out kind of what to do. And then maybe at the end, go to an attorney to talk about this estate tax return, okay? If you feel like some of the things you can do on your own, like you have these forms, you can fill them out, you do them. But I would advise with the beginning, just to protect yourself, go to an attorney, and maybe with this form, because it can be a lot of work. If there are not that many assets, let's say there's 0 inheritance tax, I mean, that's different. But if there are a lot of assets and there are a lot of contentious beneficiaries, you may want to go to an attorney. Okay, so it's important though to get these things done in a timely manner, because if you don't pay the inheritance tax, you're not going to get title to this. So this is the issue. You want to get, when you pay the inheritance tax and you get something back from Harrisburg that it's paid, you want to get any deeds changed. Okay, this is a serious issue in Philadelphia. It's a serious issue in the state of Pennsylvania, where folks just don't get the deed changed. And if you don't get the deeds changed, this is where, like, let's say you didn't get it changed, you die. There's so much deed fraud and things going on. So I have someone I use that changes deed. It's inexpensive. Just get that deed changed with your name on it. Okay, you can get that, but you have to pay this inheritance tax in order to really own this property. Okay, so if you don't pay it, so this happens sometimes, like someone will come to me and they didn't pay the inheritance tax and it's 5 years. So there's going to be interest they're going to have to pay. Okay, and the interest is like 4 or 5% per year. And sometimes it can be large, sometimes it's small, but you have to pay that because you will never really own that property. You might think you own it, but you don't. Okay, so, and if you don't probate a property, this is a whole mesh. You really don't own the property. I had one property where 8 people, they never changed the deed. They never went through probate, and they tried to, and they try to sell it. It's a huge mess. So just make sure you just get these steps done, and just, you might as well do it right in the beginning rather than like having all this stress and aggravation. We talked about the 5%. And remember, when you pay that inheritance tax, you're going to pay that with an estate check. When you pay the inheritance tax, okay, you're going to pay that inheritance tax. You're going to make out the check to the Register of Wills. Okay, and what's going to happen is that Register of Wills is going to take the check for you. You're going to make 2 copies of the inheritance tax return. So what the executor is going to have to do is bring the inheritance tax return to the Register of Wills with 2 copies. The Register of Wills handles it. Okay, you don't send it to Harrisburg, they do it. Okay, so what happens is you bring it to the office, whatever Register of Wills you're in. Let's say it's Montgomery County. You bring it. There's usually inheritance tax return, a separate room for that. Okay, you bring it there. They will stamp it for you, and you bring those 2. You have 2 copies of it, and they will send you back. Like what happens is they keep 1 copy in the Register of Wills office, and then the other copy gets sent to Harrisburg, and they'll send you a receipt. Okay. On the irs.gov about the inheritance tax, there's something called My Path, and you can actually track that. Okay, so if anybody wants any of this information, feel free to email me. So you can track. A lot of times with COVID and things like that, it took longer to get the inheritance tax straightened out, but you can see if it's gone through already. Okay, so you want to pay that, and then what you want to do now is, I think there's something, Duncan, about the status report. I'm just seeing how we are on time. Okay, we talked about paying off debts, and so okay, so the status report, you're going to also have to do other things once you do the inheritance tax form. You're going to have to do what's called an accounting. And accounting is either you can do it to the court or you're going to do it informally. And that's just keeping track. Like you're going to have to give the beneficiaries an account of what you did. Okay. So that also is something that I do a lot, just making sure that like the beneficiaries know what happened. Okay. In terms of with the money, it protects you too. And so remember that when I told you about that stock that got really low and literally there was nothing left, there was no accounting done. So the court didn't know. So this is the kind of thing why you have an accounting, because it would show that the person didn't distribute it and the beneficiary got nothing. Okay, so you're going to have to do this accounting, and you either do it to the court or you can do it informally. And then what you're going to do is call a receipt and release to all the beneficiaries that essentially says you agree with everything. Okay, all these so they call it administration for a reason, because there's just a lot of paperwork. Okay, so you're going to fill out this release, receipt and release. Okay, send to the beneficiaries, and within 2 years you're going to send the status report. Okay, and the status report is shown here, and the status report is just telling the Register of Wills that you did everything, and it's essentially closing the estate. And if you didn't close everything, you're just going to tell them that too. But all these things really, like in my office, there are more things to do, but it's just a matter of just keeping track of the deadlines, okay, and just making sure that everything's done within these deadlines. And the last thing is to, like, we talked about the executor. It's a lot in terms of stress doing all this. So the commission definitely, some of my family members, like, I don't want to take a commission, you know, it's just and literally they've spent 100 hours. So don't be afraid to take the commission, but just make sure that you tell the beneficiaries that you're doing that and you're keeping track of everything. And one last thing I just want to add, during life, it's really important to talk about, you know, we're talking about after death and a will, but a power of attorney is just so important, okay? Because power of attorney, and I know we didn't talk about guardianship tonight, but a power of attorney is a way for someone to deal with your assets while you're alive. And if you become incapacitated, like if you don't understand anymore, like you've become like, okay, I'm sick and I can't comprehend things, you can no longer get a power of attorney. Okay, so it's really important to nominate someone as your power of attorney, because if you don't get a $500 power of attorney, a guardianship over that person costs $5,000, and it's court intervention. So the one thing I just really want to end with today is, like, making sure you do your planning for power of attorneys and a will. It's really not just like throwing out a will. It's really like a life plan, even though we're talking a lot about after death, because this is all affecting your life. And what you're really trying to do is like protect your family and protect yourself. And also think about, how do you want to live? Like when I have clients come in, some of them say, oh, I want to give everything to my grandchildren, or I want to spend all my money and I don't want anything left to my will. So every person that comes in the office is different. And so that's what I try to take into account, and I tailor the wills accordingly. And the last thing too, with funerals and things like that, cremation is something that you want to think about putting in your will. That's on the rise in the last 5 years, things like that. And funeral and what you want at your funeral, that's also another conversation. But all these things, just think about seeing someone, just even to discuss them for an hour. And even if you decide, okay, I want to write my own will at home and sign it at the end, just have something on paper. And I think that's it, Duncan. Do we have time for questions? Or do we have any questions?
I believe there was one in the chat.
Okay.
It was, as a single mom with a child who is still a minor, does everything automatically go to him, or do I need to set up a trust?
That's whoever asked that question. What is the person's name who asked the question? Just kind of.
That was Lindsay Musselman.
All right. Hi, Lindsay. How are you? So no, the minor cannot get property. So this is where you really want to like set up something for the minor. Like it would have to go through a trust, as you just mentioned. Like, and if the minor got something through life insurance, they can't get it either. So it's really important to definitely set up some kind of trust. The minor cannot get property. And in that case, it's really important too to like make sure you have the executor Because what I do is in the will, I'll say the executor can deal with the minor's property. Like it gives the executor power to deal with the minor's property. Okay, so yeah, at minors, that's definitely something that you want to have a will that drafts and talks about the minor. And another thing, Lindsay, a guardian too for your minor, that is something that you put in the will. It's really, really important because you don't want the court deciding who your guardian of your child should be. So the guardian can be the trustee also, but it's really important to put that in the will. Does that answer your question? Did I answer?
She said, yes, thank you. I really need to get a will together. So.
Yeah. I mean, I feel like Duncan, I don't know. How do you feel about it? I feel like that's the one thing that people put on the back burner. But it's almost like saying like, okay, I'll do an investment. Like, would you pay like for a will, I don't know, $800 to get your will done, and you could save yourself like $3,000, you know what I mean? Like it's kind of like making that investment now and saving a lot later, I think. And it's also that horrible grief, that you're going through. And I think like what you just said too, a single mom, that's definitely where you want to have people, because you need to, you know what I mean? Like people, you don't have your spouse, or you don't have, so that is like, if you're single, definitely.
We do have another question from our friend Kathy Youngman. What are the advantages or disadvantages to having an adult child as executor?
I think it really depends on the child that you're talking about. So I think the most important thing, was it Kathy you said?
Yes.
All right. The most important thing, Kathy, though, is to discuss essentially with your adult child about this responsibility. Like I was talking about, if you have one child, it's a little bit easier, but like if you have 2 or 3, you really want to communicate about it.
And to all of them, and to all of them.
Exactly.
Like be transparent, because God forbid, the worst thing that could happen is to have, after you're gone, create this chaos, which your intention wasn't that when you planned.
Right. So that's, yeah, exactly. So your adult child, I mean, and also you want to look at like, as your executor, they might be the perfect person, but see what happens in my office is like the executor, a lot of people hire me. So I help the executor, like with lists and things like that. So they don't have to do, because we were talking, there's a lot, to do. So that's the most important, like talk to your child about, okay, would you want to be the person after I die to do these things? Also, like, is your child local? Because like, if like you live in Philly and you die in Philly and your child is like in I don't know, Florida.
On the West Coast. Yeah, that would be very difficult.
Yeah, so
very difficult.
And also some children don't want to do it. They're just like, I don't want to. And same thing with power of attorney. Like I would recommend like getting the power of attorney done. I mean, you don't know how many people have not gotten a power of attorney and people are stealing their money from them.
And also a living will. I mean,
and living will was the other thing. I mean,
living will is so important, and it's easy to do. You can write it on a piece of paper, sign it, and stick it in a.
Yeah.
What?
And like living will is so important about like, if you're a vegetable, what do you want? And all this, what it's talking about is saving everybody grief, because if they don't know with a living will what to do in the hospital, it just becomes just like, what do I do with this person? Do I keep them on life support? I mean, it's just it's all terrible.
It helps alleviate what you don't want to happen for your family, that when you are in that situation. So you're helping them so that they don't have to make these decisions when they're grieving, or when they're paralyzed and they're so upset. So
yeah, and it's exactly. And I have people too, like people have asked me like, during COVID, did you have like will? And I didn't really, but I have had people in the office that are terminally ill, that have come to do their will. And it's very difficult at that point, because, you're getting chemo, or you're doing, and to discuss these topics when you're terminally ill is just terrible. I mean, having to talk about like your living will when you're terminal. So I'm in the business where things happen in here and I think people don't normally think this way, but these things in my office happen. where like, I think because, we're talking about an attorney, like the worst case scenario does happen. So I just want to tell everyone, just get your will complete. I mean, for yourself.
Plan ahead.
Yeah,
And then any other questions? I know that we're at the time
I
where,
could start.
we've been, oh, no, this is great. No,
We got one more. Robert Smith has his
Oh,
hand
great.
up.
Oh, okay.
Hi, I have a kind of specific question.
Okay.
My father passed away 20 years ago, and
Okay.
there was no estate at all. And they never transferred the house to my mom. She's now 91. I'm the executor of her will.
Okay.
Is that something I really want to get done now before she dies?
Yeah, it's so when you said when your dad passed, right?
Yeah,
Did he, so do you know how the house was titled? Did
it's
it?
in both their names with joint
Okay.
survivorship. Everything, the reason nothing ever happened is everything
Mhm.
they owned was in joint name.
Right. Right.
survivorship.
So, okay. So
Everything
they're like,
automatically all the bank accounts. went
right,
to her.
exactly. That's what we were talking about. Like, you may not even need probate. Like, if
Right.
everything went
Right, so
directly, right, it
so
was
she
both
didn't
of their
do
names.
anything. Nobody ever did anything for
Right,
her.
right. So, I mean,
The house obviously never moved because nobody
right.
ever went to the courts and did that. So she's 91.
Mhm.
I'm going to be the executor of her estate.
Okay, got it.
Should I just wait till she passes and then do it all?
I
Or is it
mean,
better to
now,
get
so
everything
now that
ready now?
the deed, you've seen the deed, right? So it does, it does say now it went to her by the deed. And so like,
Right,
if
but
you
I
went
don't
to,
have the new deed. I don't have a new
yeah,
deed.
so but it still is, the deed still, now that he died, it's still just to her. But I mean, I recommend the new deed, like, I think is cleaner. Like, if you went to sell the property now, I mean, you need to
Yeah,
change
that's
it.
her only real asset is the property. So when she passes,
Yeah,
it'll
I
be
mean,
sold.
but,
And
right.
my sister and I each get half. It's a very simple,
Yeah,
it's a very
yeah.
simple estate. She only has the house and we'll just sell it and split it.
Yeah, I mean, I think it makes sense. I mean, to get it, I mean, there are certain things you can get, like in terms of like benefits to having that deed corrected, you know what I mean? But you can get it done now. I would just to have that corrected. I mean, I think it's important just to have that corrected.
That's what I felt too.
Yeah, I do.
Mom was like, "Oh, don't worry about it. Do it after I die." And I was like, since I was on this, I figured I'd ask that question. I can just go to probate and do that.
Yeah, and then so yeah, you can send me an email, and I recommend somebody like who does the deed, like changes it and record, because there's a recording fee, so you want to record it. That's the other thing, you know what I mean? And he does it, and it works for title. So I mean, I could do it, but it's more expensive. So I just recommend this.
Okay, that'd be great.
All right.
Wonderful.
So,
Well, thank you so much.
much.
Are there any other questions? Any other questions? Anybody else that wants to take advantage of Maureen's knowledge?
I
and
can
her
talk. The
time?
problem is I can talk for hours on the topic.
I know. Well,
I
it's
know. So
also
I need to stop.
interesting.
But thank you,
It's
everyone.
also interesting.
Yeah, and
Anybody
I
else? Well, thank you so much, Maureen, for
No
all your time, your partnership, your collaboration with
Oh,
PMC.
no problem. Thank you, guys.
And this has been wonderful. And then Duncan, I know will be able to send the PowerPoint to anybody, and
Oh, great.
which is wonderful. You can also find it on our website after PMC. I put it in the chat, pmconline.org. And then please look for more workshops through our social media platforms, Facebook. We post our workshops across the state of Pennsylvania. And
I just want to say too, feel free to contact me with any questions. And if anybody wants those, like in terms of those, I told you about where to get the inheritance tax, different things. I'm happy to answer any questions for people that attended tonight. So
wonderful. Thank you so much. Thank you, everybody. Thank you, Maureen. Happy holidays.
You too. Have a great night. Bye.
Have a great evening, everyone.